Rosa may have a claim against the Tate Gallery and the churches and the breathing specialist Mr. Khan under the tort of negligence due to the personal injury she suffered. To be successful, there must exist actionable damage, the defendant must owe the claimant a duty of care, and there must be a breach of this duty. The breach must also cause the damage. Liability may then be reduced by defences available to the claimant. Personal injury is an underlying principle of tort law. Lord Hoffman describes damage in Rothwell and Chemical Insulating Co. as an abstract concept of being worse off. Due to the development of the cancer, Rosa is clearly worse off and has suffered actionable personal physical injury. In Donahue and Stevenson, the duty of care was explained to ensure the defendant will only be liable for their carelessness when they owe the claimant a legal duty to take care. Caparo Industries and Dickman introduced two tests governing the existence of duty of care. The three-stage test requires the damage to be foreseeable, for there to be a relationship of proximity between the parties, and that it is fair, just, and reasonable to impose such a duty. Otherwise, the court will develop the law incrementally by looking to establish a duty by analogy with established authority. Robinson and Chief Constable of West Yorkshire Police explains that characteristically the latter approach is preferred by the courts. In Fairchild and Glenhaven Funeral Services, the court held multiple employers owed their employees a duty of care to prevent damaging exposure to asbestos. By analogy, the Tate Gallery could be held to owe Rosa a duty not to negligently expose her to the artium. Due to the lack of an analogy, the church's duty of care could be established by the three-stage test. It is reasonably foreseeable that a chemical solvent known to increase the risk of cancer could cause damage. At paragraph 932 of Stoven and Wise, it is shown that proximity is simply shorthand for a relationship making it fair and reasonable to impose a duty of care, thus also satisfying the requirement of justice and fairness. The goodwill inherent in volunteering should be reflected by the church's concern for their volunteers' well-being. Ultimately, it is highly likely that both the churches and the Tate owe Rosa a duty of care. The claimant must then be shown to have fallen below the standard of care set by this duty. Lord Atkin in Donahue holds that reasonable care must be taken to avoid acts which are reasonably foreseeable to cause injury. The Wagon Mound, number 2, further explains that there is more than a slight possibility of injury. The defendant's conduct may amount to a breach of duty where he failed to take precautions to minimise the risk a reasonable person would have. Again, the use of a chemical solvent known to cause cancer suggests that there was reasonably foreseeable risk that the harm could occur. A reasonable employer who uses such chemicals would, one would assume, make themselves aware of the risks involved and protect themselves and their employees. It must also be proven that the breach of the duty of care was the factual and legal cause of the damage suffered by Rosa. As Lord Bingham repeated in Fairchild, the claimant was required to prove on the balance of probabilities that the breach of duty caused the damage by showing that but for the breach he would not have suffered the damage. In the case of multiple sources of exposure, Bonington, Castings and Wardlaw established that the question is whether the breach of duty caused or materially contributed to the injury. Sienkiewicz and Grief held that a material increase equated to more than a de minimis exposure to the risk. In Bonington, the successful claimant was exposed to the risk for 8 years. Rosa could clearly argue that, since she worked at the Tate Gallery for 5 years, it was likely that the resulting exposure was greater than de minimis. Hotby and Brigham and Cowan also established that, for want of evidence suggesting any fairer basis of appointment, those held liable for the claimant's injury would have responsibility divided between them on a time exposure basis. In Carder and University of Exeter, the defendant was held liable for contributing only 2.3% of the damage. Therefore, Rosa's minimal time spent volunteering in the churches could still amount to a material contribution establishing liability. Developing material contribution, Fairchild created an exception to the above but-for test when there is no way of identifying the source of the fibres which initiated the cancer. This rock of uncertainty, as was made clear in Sienkiewicz, is the basis upon which the Fairchild exception is applied. This uncertainty is clearly present in Rosa's case, as it is unknown whether the cancer develops as a result of cumulative exposure or whether a single exposure is all that is needed. After Hennigan and Manchester Dry Docks Limited, where Fairchild was applied to a lung cancer claim, it is clear that the Fairchild exception could be relied upon by Rosa. By relying on Fairchild, Rosa could therefore prove that the defendant's breach was the factual cause of her injury. The defendants must also be the legal cause of the damage. As held in the Wagon Mound number 1, if the damage is too remote a consequence of the risk, and the defendant will not be liable. Narrowing this test, Storches argue that it is not the type of harm suffered which should be assessed, but what the foreseeable risks associated with the defendant's negligence are. The foreseeable risk of using artium is that cancer may develop. The harm caused directly flows from the foreseeable risk of injury and is not too remote. The Churches and Tate may try to argue that the later misdiagnosis of Rosa's condition was a negligent act which constituted a novus actus interveniens. However, as in Baker and Willoughby, if the later injury merely becomes a concurrent cause of, or, as in Knightley and Johns, the sequence of events following from the initial negligence were a natural and probable consequence of it, the act cannot be intervening. Arguably, Rosa already had cancer before the proposed negligent act of the doctor, and the doctor's act did not cause the cancer. The deteriorating condition was a natural and probable consequence of the initial negligent exposure. Rosa has a strong case, therefore, to argue that both the Churches and the Tate Gallery were negligent when exposing her to the artium. However, the defendants could potentially rely on two defences to reduce their liability. If Rosa was a volunteer in the Churches, they may argue that she voluntarily assumed the risk of working with the artium under volenti non fit injuria. However, in the absence of express assumption, Smith and Barker establishes that mere knowledge of the risk is not sufficient. As suggested by Jaffe, where the claimant merely freely encounters a risk which he is aware of, the appropriate defence is contributory negligence. It is unknown whether Rosa was aware of the risk at all, let alone expressly accepting it. The fact she used the solvent in personal work would suggest she was blissfully unaware. Rosa herself clearly contributed to the development of the cancer by using atrium herself. The Law Reform Contributory Negligence Act 1945 states that contributory negligence is only a partial defence, and Section 1.1 states that the courts can reduce damages to a just and equitable extent. In Jones and Liveox Quarries, Lord Denning stated that a person is guilty of contributory negligence if he ought to have foreseen that, if he did not act reasonably, he might be hurt himself. Although Rosa may not have been aware of the risk in using atrium, this does not defeat foreseeability, as the question is not whether it was foreseeable to her, but whether it ought to have been objectively foreseeable. If the risk associated with using artium ought to be reasonably foreseeable to the defendants, it follows it should also be so to Rosa. Though Rosa is likely contributory negligence, Section 1.1 does not specify how responsibility should be apportioned. Lord Reach's speech in Jackson and Murray shows that this is a rough and ready exercise where the courts take into consideration both the causative potency of the acts and their blameworthiness. Rosa may also seek to bring a claim against her doctor for the negligent diagnosis of her illness by satisfying the same conditions as above. Under the Caparo incremental test, Mr. Khan owed a duty of care not to diagnose or treat his patient negligently by analogy with the precedents that in Bolan, the standard of care was held to exist, was one of the ordinary skilled man exercising and professing to have that special skill, and not simply that one of the reasonable man. Further, Bolito and City and Hackney Health Authority establishes that, in a case where the medical opinion is not capable of withstanding logical analysis, the judge is entitled to declare it unreasonable. The modification of Bolan has been applauded, namely by Teff at paragraph 483, who states that Bolito should reduce the risk of legitimizing the lowest common denominator of accepted practice. Following Bolito, if a judge were to conclude that, on the evidence presented to him, Mr. Khan reached an illogical conclusion, a breach of this duty would have occurred. Again, causation must be proven. Arguably, but for the doctor's breach, Rosa would still have had cancer, and so the but-for test is not satisfied. Instead of bringing a claim of physical damage, Rosa could potentially bring a claim for lost chance of recovery, as discussed in Gregg and Scott, following the misdiagnosis of a cancerous tumour as harmless. Although the majority were unwilling to accept that lost chance of recovery was compensatable, Lord Nichols' dissent, through his criticism of the fact that a patient could recover damages only if their initial prospects of recovery were more than 50%, suggests lost chance is actionable if Rosa could prove that her chance of recovery had initially been 55%. Lord Nichols himself argues that if the patient suffers a significant diminution of their ability to recover due to negligent medical diagnosis, the way ahead is that the diminution shall become actionable damage. Yet, as the law stands today, the spirit of the decision in Gregg is interpreted by Lord Neuberger in Wright and Cambridge Medical group to show that loss of chance shall have no place in personal injury actions, especially clinical negligence, and Rosa's claim against Mr. Khan would fail as she cannot prove his action was the factual cause of the damage suffered.